Good evening, everyone. Sorry we lost a few people. As I mentioned, sometimes we have these weird intermittent things with this particular technology, and we're not sure. We've solved it for a month, and now it's back doing weird stuff. We'll sort it out. But tonight we have Marcus Reed again. For those of you who took 401, which is most of you, Marcus is our favorite lawyer. And because in this class we cover capital investments and the team and employment, those are the legal issues we're going to talk about tonight. And we had a few questions. I think you have the ones from Chad.
Yeah.
So there were a few questions from Chad. I didn't see any other questions come in. We'll have plenty of time for you guys to ask questions because this class is not as big as the 401 class, which was a monstrous size. So let's get started in case we have a technical glitch again. Last week we were able to work around it really fast, but for some reason I had to restart it to make the slides go. So let's go.
And a couple of you asked some questions directly to me by email after the last time, and that's totally fine. If you want to email me directly, I absolutely welcome your questions. So feel free to use that email address that's up on the screen right now. And we'll post the slides too so that you can have all this information. So I'm going to start with a couple of questions that were follow-ups from last time. After the legal disclaimer, of course, that the legal information contained within this presentation is intended to inform you about legal matters of current interest. It is not intended as legal advice. We recommend that you not act upon the information contained in this presentation without seeking professional counsel.
That's the CYA
I need to learn how to say that really fast. So the question asked was,
I think you're allowed one free question.
That's right. But maybe buy one, get one free. We'll see. The question asked was, do most startup businesses designate an independent agency as their registered agent, or do they use the company founder? This may vary state to state, but I don't think it does. I believe in all 50 states you can use anyone as your registered agent who is domiciled within that state. So as long as there's a physical location within that state, they can be your registered agent. Often that's going to be one of the founders of the business. Maybe even more often it's going to be the business's attorney, or there are third-party registered agent services out there that you can pay $150 a month or something like that, or a year or something like that, and they will be a registered agent. And a registered agent just means that that person is your agent for receiving legal process. So if somebody sues you and needs to serve a lawsuit on you, that's the person who's going to be served upon in a lot of cases. The next question was, if I start an LLC, do I have to worry about my investors? For example, if one of my investors has financial issues, can the court trace back to their investment in my company and try to take the funds? Generally, no, unless that money was somehow dirty money that got into your company somehow. That's not going to be an issue. For instance, if they file bankruptcy, or if they get into legal problems, or if they have a creditor after them, they're not going to be coming after the money that's already within your company. That money should, in most cases, be safe. I suppose there are some incidents where maybe that money was laundered money, or it was gained somehow in violation of the law, and maybe the feds could come in and pull those funds out. That's going to be a rare case. And next, is there any advantage to registering the company in another state? For example, if I register in Delaware, do I get those state tax benefits for the income I earn with the LLC, or will I still pay income tax at the place where I reside, which is Virginia? A lot of companies do register in Delaware and Nevada and a few other beneficial states. For small companies, that's generally not going to be for tax reasons. For larger companies, it's going to be for the benefits you get from using Delaware law. Delaware has a really good set of courts. They have a good established set of case law for governing business law. So Delaware is a great place for big companies and any company that's going to go public to form. But in most cases, when you're forming as a small business, the state that you are forming in is going to be a fine choice. And when you are taxed, especially if you're an LLC, the profits from the LLC are going to flow through to you individually anyway, so you're going to be paying taxes as an individual, not as a business. And if you reside in Virginia, you're going to be paying your income taxes in Virginia. So moving on to this week's topics, we're going to start with leasing. This is a huge issue for breweries. If any of you have been out there looking for a space and trying to get into a lease, you know how big of an issue this is. Space is hard to find in a lot of areas, and when you find it, there are a lot of considerations that go into this. First and foremost, you're going to be looking at zoning. Can you even start a brewery in this area that you're looking at? Is the present use of that facility going to be compatible with a brewery, or are you going to have to get a change of use? And when you go through zoning changes and zoning variances and changes of use, that can be a very extensive and expensive process. So look at that right up front, and you're going to want to assess those issues very early on. You're going to look at the availability of expansion space. Maybe you're getting a multi-unit facility and you're just going to get one unit out of that facility. Well, maybe you have an intention of expanding into that, into the other units, which is great, but you need to provide for that in the lease. So build in a right of first refusal to your lease so that you can, if that space becomes available, you get the first shot at it. If you're going to be in a space for 10, 20 years, chances are one of those adjacent spaces is going to become available at some point. So be in a position to snatch it up. The accessibility of your loading dock can be extremely important, especially when you start distributing through a third-party wholesaler. They need to back those trucks up into there, and it's going to be difficult for them if there are other businesses that are getting in your way, or if you have to get an easement to access that area. That's not going to be a good situation for you. So make sure it's got an accessible loading dock at the times you need it to be accessible. The structural components I'm talking about are things like the foundation of the building and floors. Things that a lot of businesses don't have to worry about can be extremely important to the brewery. And like Bob points out, ceiling heights can be extremely important. You need that floor to have the weight-bearing capacity for your tanks, and those tanks when they're completely full of beer. You need to have if you're going to go through the ceiling, maybe you're going to run your glycol through the ceiling or something like that, or silo. You need to be able to do that and make sure that the ceiling is structurally sound for all that kind of thing. If you're going to have a tap room or a pub, there can be issues with occupancy and some upgrades you might need. For instance, in Portland, seismic is always an issue. And a lot of times you're going to have to get seismic upgrades before you have a certain amount of occupancy within your tap room. Those can be extremely expensive. Negotiate those up front with your landlord. Fire suppression, sprinkler systems is another big item like that. Parking, of course, is a big issue. Will you have some exclusive use to an outdoor area for seating? Other uses for outdoor areas can be if you're going to put your glycol system outside, or if you're going to have a silo located outside, you need to make sure that that's set aside in the lease for your exclusive use. Neighborhood is a big consideration when it comes to noise and odor limitations. If you have residents living in the same building as you, or if you have businesses nearby or a school nearby that may be sensitive to the odors that come from a brewery, you need to know that in advance and make sure you're not stepping into a problem there.
Oh, I should mention, for a lot of the construction issues coming up in wastewater disposal, in 2 weeks, I think we're having Thad from Portland Kettle Works. He's also a brewery, cidery contractor. He's built out a few of them. So he's going to be talking about very specific issues around building your site, leasing your site, and what to do in that space, and things about disposing wastewater. So we'll let Marcus stick to the legal side, so we can have Thad cover those issues.
And another great resource for these issues is an architect or a designer. Architects deal with these zoning and use issues all the time. They deal with the structural issues, of course, so consult with a good architect. And there are architects who have specializations in breweries and restaurants, so find one of those. All right, let's talk about some of the basic terms of a lease that you can negotiate. Tenant improvements can be a huge benefit to a new business who maybe you don't have all the funding you need to do all the improvements and the build out to your facility. Well, sometimes landlords will do that build out for you. Sometimes they'll put in some big ticket items for you, even such as ADA compliant restrooms. They'll do the seismic and sprinkler upgrades we just talked about. They'll sometimes do storefront improvements, put in a roll-up door for you, landscape the place. There are any number of things landlords can do for you. The only caveat I'll put on that is sometimes those improvements are basically the cost of those improvements, while they seem like they're free for you, are basically just being built into your monthly rent amount, which it's a hidden cost, but it's actually not a bad thing that they do that. It still means they're basically financing these improvements for you. But the only exception to that benefit is maybe you can do these improvements for yourself with a little bit cheaper in the long run. It's always hard to determine how much they're building into the rent amount, but maybe sometimes you can do some of these improvements yourself and save yourself some money if you have that cash up front to do that. Rent and rent abatements. Rent, of course, is a hugely negotiated term of a lease. You want to make sure you know what kind of rent you're paying. Are you paying a gross rent, which includes everything in it from including taxes and insurance and maintenance costs and so forth? Or are you in a triple net lease where you are paying a base rent amount, and then on top of that you're paying for these extra items that you'll be billed for, usually on a monthly basis? Rent abatements are where the landlord is going to give you a couple of months off in the beginning of your lease term. This can be fantastic, especially during your build-out period where you don't have any income. You're building a brewery, you're getting your equipment in, you have no cash flow. So this can help you put off some of your rent payments until maybe sometimes third, fourth, even fifth month of the lease.
Someone's saying if equipment takes 24 weeks to get, at what point should facility warehouse be obtained? I say as soon as possible.
As soon as possible, absolutely.
It's really hard to
Absolutely.
find the right place. And if John from Ecliptic that just opened here, I think it took him a year and a half to get.
It took a long time.
He had his equipment
a grueling
before.
process.
Yeah, so I'd find it as soon as you can, and then negotiate those rent abatements.
And a major consideration in that is you can't even apply with the TTB until you have your lease. The TTB can take 90 days or 100 days. In John's case, I think it's more than 100 days. So once you get your lease, you can get that process started with the TTB, get your equipment in. The equipment can be tough because the lead times around here are going up to 6-8 months sometimes to get your equipment in. So you might have to order that early on, or used equipment is always a good idea too, but that's kind of outside of the scope of this presentation. But yeah, the timing is very difficult, and we'll talk a little bit more about that on the next screen here. Term and renewal options. Make sure you're not getting over your head on term. You may think you're going to be in this space for the next 20 years. That's great, but start with 5 years and then get 3 5-year extensions. The shorter term, the better in a lot of cases, because in that worst case scenario where you need to get out of your lease, you're going to want it to be short. And also at the end of that 5 years, you can consider whether you need to move to another premises, renegotiate your lease. The options are opened up for you a little bit. For utilities, basically you just need to know who's paying for what. And a lot of times, for instance, with a triple net lease, the landlord will pay the utilities and then they'll portion that cost out to all the tenants of the facility. But with breweries, they take exception to that often because of the incredible amounts of water that you guys use. So a lot of times they'll make sure that's separately metered and you're going to be paying for that separately.
And that would be the same for cider makers, a little less water for distilleries.
Yeah. Indemnification is one of those legal provisions that a lot of people, when they review a lease, they just kind of gloss over it because it's like, what does this even mean? But it's hugely important if you get into a dispute or if your landlord gets into a dispute. For instance, say something happens in a common area of the building. A patron is injured, slips and falls in a common area of a building, and they sue everybody who's around. They sue you because you are in the space where the patron is visiting. but really the accident was caused by a condition of the common area. You want to make sure that the landlord is going to cover your legal expenses and your damages if you get swept up into that lawsuit. In the same token, the landlord, of course, is going to want you to indemnify them, and that's part of every commercial lease that the landlord is going to give you. A lot of times it'll be unilateral indemnification, though, and you want to change that to be bilateral. Assignment can be a big issue in any lease. The landlord is usually going to have the right to assign. Transfers of commercial real estate happen all the time, and they want to be able to do that seamlessly without your consent. It can be important for you to make sure that an assignment provision is built in that says at least that if you want to assign the space or sublease it out to somebody else, that they have to be reasonable in their granting consent to that assignment. You don't want it to be that they can just deny you for any reason whatsoever. And it's a big issue with breweries because you get into a space, you grow like crazy, and maybe you need to get out and get into another space to better accommodate you. And the best way to do that is going to be to sublease or assign that space. So make sure you can do it. Personal guarantees. A lot of you, if you're just starting a brewery, are going to be a new business, and landlords are almost always going to require a personal guarantee for a new business, simply because there's no business financial history for them to be secured by. So be prepared to sign a personal guarantee, but that doesn't mean you have to be personally guaranteeing the lease for the entire lease term. You can sometimes negotiate an expiration to that personal guarantee. So maybe the guarantee expires after the initial term, but your renewal terms, you don't have a guarantee. It's always worth a shot.
But isn't there a concern with landlords hiking up the prices after the lease?
That's one reason to put in a renewal term. And the renewal provisions, you can negotiate to either have a fixed rent increase. A lot of times rent increases are by a percentage increase. So maybe the rent increase is 2% per year. So you know exactly how much your rent's going to go up every year. When you get into a renewal term, sometimes you just carry that forward. The percentage increase continues 2% a year, or whatever it is. But sometimes the landlord will put in this provision about basically market rate. So you basically reassess the rental value of the property for the new renewal term. You want to try to avoid that in a lot of cases because it's almost never going to work in your favor. It's usually the rent's never going to go down from that. It's only going to go up, and the landlord's going to have a lot of discretion in how much it goes up. So your lease might say, landlord can choose what it thinks is the market value of the rent, and then if you want to contest that, you can do that. But then if you're wrong in contesting it through an appraisal or whatever method, you're going to end up paying attorney fees, and it can become problematic. So try to build in some kind of fixed rental increase if you can.
What are typical?
So CAMs are talking about common area maintenance. It really varies from lease to lease. It just depends on what all is included in your triple nets and your common area maintenance charges. So it's hard to say. And of course, those common area maintenance charges are going to be apportioned by how much of the square footage of that premises you're taking up. So if you have 25% of the space, you're going to pay 25% of CAMs. It's hard to say what a typical percentage is. And Ben makes a really good point. Always a good idea to have a lawyer look over a lease. What I charge look over a lease, it varies a ton depending on the lease. Sometimes if it's a lease form I've worked with before, I can review a lease in 2 hours and it costs about $500. But I've had lease negotiations go up to $2,500, $3,000 because you just don't know what the landlord is going to do. If the landlord comes back and rejects all of your changes and you end up negotiating and going back and forth a lot, it can become rather expensive. And another piece of advice on negotiating leases, get a letter of intent in place up front. Get the basic terms of the lease negotiated. Too many times, even with a letter of intent in place, I've seen landlords back out at the last minute from a lease. Landlords get sketchy about breweries. They're new businesses. They're manufacturers. They have a retail element with possible crowds coming in. they just get nervous about them. And I've had 2 landlords already back out from brewery leases, and it's a terrible experience for the brewery. They throw a lot of money at nothing, and it's no good for anybody. So get a letter of intent in place. Make sure those terms are sealed up before you get into the lease negotiation. What do you mean by basic terms?
Well, the terms would probably be these types of things.
Yeah, those are the basic.
Rent.
Yeah, those are the things you're going to be negotiating, plus some issues we'll talk about in the next slide, which are brewery-specific terms.
But these also, we keep saying brewery, but it can also apply to distilleries and cider makers.
Yeah, absolutely.
General.
Just read into that. Cider makers, distillers, when I say brewers, every time.
All applicable.
Absolutely. So, and by basic terms, you might also mean there are a lot of lease forms out there, like a lot of state associations, real estate associations will have forms out there that have the basic terms for a commercial real estate transaction. Some are more landlord-friendly, some are more tenant-friendly, and that's the reason to have a lawyer look at it. Real estate lawyers are very familiar with those forms and can basically bring it back from being a landlord-friendly lease to making it more balanced. So with these brewery-specific terms, the biggest one up front on a lease is going to be a termination contingency. And what I'm talking about there is we talked about how you can't even apply with the TTB until you get your lease. So that puts brewers in kind of an interesting conundrum where you're signed into a lease, but you don't know if you have approval from the TTB, and most likely you don't know if you have approval from your state beverage control agency. So we build in these termination contingencies, and basically the way that works is for a period of 3 or 4 months, you want it to be at least 3 months in most cases, you're going to have an out from your lease. You can terminate that lease if your licensing doesn't go through. Of course, that becomes a concern for a landlord who says, I don't want to go through this whole process just to have you back out. So they're going to put some conditions in place. A lot of times it's going to be things like you can't do any major improvements to the facility. You have to pay an additional deposit that you'll lose if you terminate. Any rent abatements are going to be delayed until after the termination contingency period. Just things that the landlord's going to want to be secure that they're not going to take a big loss if you back out of the deal. But it's very important to have that in there.
There's 6 to 9 months for TTB processing.
Yeah, a lot of landlords will balk at that, and with a longer approval period for anything, whether you're dealing with the city, the state, the TTB, you still need those contingencies, but you're just going to have to build in some protection. You're going to have to negotiate that with the landlord, build in some protections that make them secure. Remember, you're still paying rent during this time, so they have a tenant. And as long as you're not doing anything to devalue the space during that time, they might be comfortable with that. And if you build in enough a deposit where they have their rent covered for a month or two if you bow out, gives them time to get a new tenant in, they may be willing to work with you. It may be too much for a lot of landlords to handle, but there will be landlords who will work with you. And how can you sweeten the pot? Just like I talked about, you add that extra deposit amount in, make sure that you aren't getting any rent abatements during that time. The deposit can be a big one. I've seen them where it'll be a $4,000 a month rent payment, but the brewer will pay a $10,000 deposit. Now that brewery is going to take a big loss if they back out of this space, but it's not as big of a loss as they'll take being in a 5-year lease and having no way out of it. So that can give you some security.
The distillery issue will come in when we have, in a couple weeks when our building guy comes, but you have some points there. Liability related to fire explosive stuff. Yeah.
Oh, right, yeah.
Although I've seen some sketchy stuff.
Refundable deposit, Bob, yeah, that deposit's going to be just like any other security deposit you put down. It's in most cases going to be refundable. Of course, that's always negotiable, but you'll want to negotiate it to be refundable. Sometimes you might even be able to get the additional deposit refunded after the contingency period expires. So maybe you put down 10 grand as a as a security deposit, but after the contingency expires, you get half of it back or something like that. It's all negotiable. Use of the premises, just be very specific in how the premises use is listed in your lease. The language I like to use for a brewery is, it can be used for a brewery, tasting room, and retail and wholesale sales, which may include the manufacturing, packaging, distribution, and sale of malt beverages, wine, cider, and related products. That keeps it nice and open in case your business plan changes down the road. Maybe you want to open up a new product line, expand your tap room into a brew pub, something like that that wouldn't technically fall under the use of the premises in the lease. For business hours, just be careful not to limit yourself too much. A lot of landlords will want to know your business hours, and that might even be a big concern for them. Just know that business hours for a brewery can be 24 hours a day. You might be pulling an all-night brew session. Your tap room may only be open until 10, but you want to make sure that you have access to the premises at all hours, and you're not going to have any problems with that. Outdoor spaces we talked about a little bit. Just make sure you reserve exclusive use for seating and for any equipment you're going to be locating outside. Environmental covenants. The lease will often contain a representation and warranty that you're not going to use any hazardous substances or store any hazardous substances. You're going to be using some hazardous substances probably. You may be using sodium hydroxide as a cleaning agent. So if you're going to be storing caustic on site, that's hazardous substance, and you should put an exception for that in your lease. Alterations, because breweries have typically a large amount of alterations that need to be done, like floor drains being put in, structural changes, holes in the ceiling. These are pretty big items. Get approval for those from your landlord in advance. Most leases are going to have a provision that requires you to get the consent of the landlord before making alterations. Get those in advance to make sure he's on board with your plan. Bring in your designer, your architect on that, and present the plans to them. And they may not need to be involved, but they may want to be very involved with that process. Insurance, we'll talk about that more in a few slides, but your lease is going to require that you have certain amounts of insurance coverage, which are going to dictate a lot of the insurance that you get for your brewery. So move on to licensing here. We talked a little bit about this, that you can't really get into this process much until you have your lease signed. Some states will allow you to get into the process a little bit earlier. In Oregon, if you have a letter of intent in place for a lease, they'll let you begin the process of getting your licensing. So on basically a broad level, the licensing on the federal level is controlled by the Federal Alcohol Administration Act and by the Internal Revenue Code. So the FFA or the FAA covers permits, labeling, advertising, trade practices, and the government health warning statement that you see on every bottle of alcohol in the country. The IRC is going to cover the taxes, registration, bonds, production, record keeping, and things like that. For the TTB brewer's permit process, I said you can't start the process until you have your lease, but there are things you can do to get started on that early on. It's quite an extensive form, so go to the ttb.gov website, get registered, check it out, and start filling the thing out. You basically just save the form online, and you don't submit it until you have that lease in place and you've uploaded all your documents. You can get the process started, get your individual histories, and so those are on record. And the earlier the better. The sooner you can get into that process, the better. TTB is very helpful at walking you through the process. I work with them frequently, and they've never given me the "you should know that already" kind of attitude. They're very helpful, and they're good at guiding brewers through that process.
And hopefully you have an equivalent agency for those of you in Spain, Germany, and where else do we have somebody? Africa, I think.
I wish I could give more information on that, but I've never formed a brewery outside of the continental United
Canada,
States.
yes, we have our Canadians. Yes, they have their own liquor control board. Yay! With all the same type of hurdles to jump through.
That's right. Maybe not as much as the U.S. has. We love our paperwork here, as one of my New Zealand clients tells me.
Well, I don't know. I think they probably like it just as much in Canada, for alcohol at least.
So that's the TTB in a nutshell. I mean, the TTB is not in the business of denying applications for a brewer's permit or for any kind of alcohol production. They just want to make sure you're not associated with organized crime, laundering money, or trafficking something that you shouldn't be trafficking. So they're going to look at your individual history, your criminal history. They're going to look at where the money's coming from and things like that.
Yes, they want all this tax money, so they want to make it easy.
It's all about protecting their product. They're going to make sure you have very secure systems at your brewery so that your taxable product is not removed when it shouldn't be. So we get into state law. That varies quite a bit, of course, as to how the licensing works. Most of the states are on the 3-tier system. I can't even say most of them are, but many of them you're going to encounter the 3-tier system. So you have your distributors, your suppliers, and your retailers. And you need to pay close attention to how those 3 tiers can be, how they can be blended. In most states, they're going to require a lot of separation between those tiers. However, of course, if you're a brew pub, you may be asking, how is it then that I can manufacture beer, self-distribute beer, and sell beer at retail? Well, there, of course, are exceptions. So just make sure to read very carefully your state laws on what you can do, who can be an owner in your company, things like that. If you are going to be shipping beer into another state, you, of course, have to look at that state's licensing procedures and make sure that you are in compliance with that. You're going to need something like a certificate of approval or a non-resident manufacturer's permit to go into most states. Also pay attention to local ordinances. State liquor licenses typically will not trump local or county laws and codes. So an example of that is the state may license you for your brewery, but you may not be in compliance with zoning ordinances for your county. So make sure that you're in compliance with all those county laws as well.
This is what we're seeing with marijuana sales now too.
Absolutely.
The state says okay, and the counties don't want the distribution sites there.
That's a big issue in our state right now. It's my next practice area.
I know. I think you should extend into it. And we're going to have it too. We're going to have the business of supply chain management of marijuana.
There you go. There you go.
Medical.
Another thing about TTB and possibly your state agency as well. If you make any changes to your brewery, and it can be pretty small changes to your brewery, you need to let the TTB know. That can be anything from having a new owner to buying a new piece of equipment. TTB likes to know about that piece of equipment. So let them know very early about that piece of equipment, because you can't technically use it until the TTB has stamped its approval on it.
Not even for test batches.
That's right.
Going down the drain.
Yep.
Or somewhere.
All right, let's talk about distribution. This is one of my favorite areas in brewery law, and I work in this area a ton because it's just crazy laws, and it's complicated, and it's incredibly important for your brewery, cidery, or distillery. The distribution laws are going to vary state to state, and they vary tremendously. There are a lot of states, I think 18 states now, that are control states. That can have varying effects on your business depending on what you're doing. If you're a brewery, the control state element may not have a huge effect. But if you're a distillery, it may have a massive effect on your business, because you may be selling all of your products to the state, who will then distribute it to their state-run retailers. For most states, there's going to be some kind of franchise law in place that governs the relationship between a brewery and a distributor. At this point, those only most of them only apply to malt beverage distribution. If you're a cidery or a distillery, you're probably not going to be subject to those franchise laws. Of course, distillery, if you're in a control state, you have bigger things to worry about. The franchise laws are another area that just vary tremendously. There's some amount of uniformity in that most of them require that there's some amount of permanence to the agreement. And this is an interesting area of the law where if you enter into a distribution agreement with a distributor, it's kind of like a marriage. You are basically marrying that distributor, forming a partnership that is a very difficult partnership to get out of. In some states like Oregon, you can get out of them, but you're going to pay to do it. If your distributor is not in breach of their agreement, you're going to have to pay what they call market value for your brand with that distributor. That market value can range from something like 3 to 6 times the gross revenue of your distributor for distributing your product over the last year. That can be a large amount of money. So just imagine taking how much money your distributor made off of your brewery in the past year and basically multiplying that by between 3 and 6. We'll talk about that in a little bit and when it comes to negotiating the terms of the distribution agreement. So if there's no franchise law, that distribution agreement is going to govern the relationship. And you need to be very careful about what that agreement says. If there is franchise law, you can put whatever you want into that distribution agreement, but that franchise law is going to trump the agreement. So you may put in that you can terminate the agreement with 30 days notice and you don't have to pay the distributor thing. The distributor might sign that agreement, all well and good, until you try to enforce that and the distributor says, sorry, that's not enforceable under the franchise laws. So let's talk about the elements of a distribution agreement. The territory is a big part of it. That's why it's a franchise agreement. It's going to establish a territory for that distributor. So that territory is usually going to be delineated by county. So you have maybe just one county for that distributor, or maybe you have every county in the state. Make sure that you're well aware of what counties you're getting into, and make sure that your distributor is going to service those counties very well. Too often, breweries sign up for these huge swaths of territory with their distributor, and then they get upset when they have entire counties where their beer is not being distributed. So be careful of that. You can also designate, in most states, the brands that are to be distributed by that distributor. Most agreements, most distributors are going to require that you have all of your brands listed and all future brands listed. One trick that I like to use for this is to say Brewery A's products will be distributed by this distributor for basically this particular brand name. That way, if you come up with other brands, if you want to come up with a parallel brand of beers, maybe under a completely different brand, you can go to another distributor, or you can self-distribute it. It's excluded from that agreement. Some distributors don't like that. They just want an all-encompassing agreement, but a lot of them will agree to it. That also gives you a little bit of an out if things just go completely haywire with your distributor and you need to get out. You can just start up a new brand and go another direction. And I've actually seen it happen before, so it's a realistic possibility. The distribution agreement is going to govern the distributor's use of intellectual property. So you are the owner of your logo and your brand and all the intellectual property that comes along with that. You're basically licensing the use of that to your distributor. So they can take that logo and they can throw it all over the place, and you want them to. You want them to put it on their trucks and on their T-shirts and on their little trinkets that they give out. But you also want them to take good care of your intellectual property. So make sure you have some protections in there saying that it would be in breach of the agreement if they were in any way damaging the goodwill of your company by damaging your intellectual property, which means just giving you a bad name, basically. Pricing and payment terms are, of course, important, but you're very limited in how you can dictate You're very limited in how you can dictate the pricing of the distributor to the retailer. In most states, that's going to be illegal. But you can dictate your own price to the distributor, of course. So just make sure you're giving them a competitive price, that you know what their margins are, so you know what your product's going to end up costing on the shelf, and price your product likewise. And for payment terms, just make sure you have your cash flow moving fast enough. So maybe you have, maybe they suggest a 30-day payment term. Maybe you suggest a 10-day payment term. That gets the money moving faster, keeps your cash flow moving, which is a very good thing for you. Continuing on with these, advertising promotion. Keep in mind with your distributor that when you meet with the distributor the first time, the conversation might be about how they're going to sell your beer, how they're going to market your beer to the trade and get your beer into such and such accounts and so forth. That's great, and if they do that, that's fantastic, and you should put pressure on them to do things like that. In the end, though, your distributor is your distributor. You're going to have to be out there selling the beer yourself, and then they'll get it from one place to another. So just don't fall into the trap of thinking that, okay, now I have a distributor, so I can just forget about this whole sales part and just keep making beer. My beer is just going to start flying off the shelves. You need to be out there and active and working with your distributor as a partner.
I think that goes to Bob's point. The bigger the territory, the more sales personnel you need.
Absolutely.
Or else you spread yourself really thin.
Absolutely.
Be out there.
Yep. Yeah, don't expect your beer to be moving very well if you don't have a sales presence in that area. You can build in some requirements into your distribution agreement for advertising and promotion. One fun thing to do with your distributor is set up a marketing fund, which is basically for every case or case equivalent of your beer that they're selling, they're going to pitch in $1 or 50 cents or something like that into a marketing fund. And this doesn't necessarily have to be an account that this money is going into. It's basically a budget for them to work with. And then they're going to pay for advertising and promotional materials for your brewery. That's a great benefit to you. They're probably going to build it into their pricing in some way, but it really puts the onus on the distributor to be out there and marketing your brewery and your beers. Put quality controls into your distribution agreement. Put a bunch of them in. If you're concerned about shelf life, make sure you define very clearly what shelf life you're willing to live with. I often put in a shelf life of something like 120 days for in the warehouse. So if your beer is sitting in their warehouse for more than 120 days, they can't put it out into the trade. They have to destroy it, get it back to you, something else. That beer has expired with them, and it's on their dime. The same token, maybe you have a 180-day shelf life in the trade. So if you are out at a retailer and you find one of your beers that's been sitting there for a year, and you know that that's a bad beer, they're in breach of their agreement technically, because they are policing your brand and making sure your beer has the quality that you want it to be at. Refrigeration is another big one. Make sure the beer is being stored at the temperature you want it to be stored at. Make sure they have a refrigerated, temperature-controlled warehouse and it's not sitting in 90-degree heat all day. Another issue can be delivery. So make sure you know who's responsible for getting the beer from one place to another, and make sure you know where the risk of loss is going to transfer. So what I mean by that is, if you are going to be just putting your beer on the dock and the distributor pulls up in his truck, pulls out a loader and moves the pallet onto the truck, you want the risk of loss on that beer to transfer as soon as that distributor picks it up. So if something happens in transit, if something happens even in loading onto that truck, it's not your responsibility, it's the distributor's responsibility. That can be a big issue. Also, just make sure you know who's responsible for arranging delivery. Sometimes the distributor will want you to have the beer shipped to them. Maybe that's not the business you want to be in, so maybe you want your distributor to handle that kind of thing. Dispute resolution, you can build in arbitration provisions, which can reduce legal costs if you get into an argument or dispute with your distributor. Sometimes the state's statute is going to require that you get into arbitration if it's something over if it's a dispute over termination. So if you try to terminate your distribution agreement and a dispute arises because you're saying you're trying to terminate for cause, they say that they are not in breach of the agreement, then this gives you, or this forces the whole issue into arbitration. You handle it there. Purchase of brand rights can be really important, especially if you have an established territory. If you've already established a distribution territory through self-distribution, and you should check with your state if you're allowed to self-distribute in that state, or if you've maybe established your market through another distributor, your brand is going to have value. Your market is going to have value. And you may be able to get that distributor to pay for that value. Oftentimes it's going to be based on a similar formula to the termination formula. So maybe they're going to pay you 4 times the market value for your distribution rights or something like that. Just don't give up that value. That can be a lot of money. And some of the payouts are becoming quite large for these distribution rights. And finally, it's a negotiation. Don't be afraid to ask for more favorable terms when you're negotiating these things. For a number of years, it seems the brewers have been negotiating these agreements themselves and really kind of getting themselves into a bind when it comes time to get out of the agreement, or if they're just not happy with how their distributor is performing. So negotiate the terms, have a lawyer review the things, make sure you're getting the agreement you want. And if they won't give you the agreement you want, go to another distributor. There are more out there. You have some leverage here, even if you don't think you do.
This question about spirit. How can you negotiate increasing sales of your spirit is selling? And, well, this could be a spirit or it could be another beverage, the same issue. And the distributor up and asks for 3 or 4 times the product, and you can't deliver it due to some issue, aging, equipment. This was a New Belgium problem. They didn't have enough kegs when they were picked up in Texas.
Yeah.
So how can you protect yourself if you can't actually deliver what they want?
So what you want to build into your distribution agreement there is you want to make sure that in a lot of just template distribution agreements, there's going to be a provision that provides if you don't have enough product to distribute to your entire distribution network, then you'll allocate it equitably among your distributors. What that means, of course, is if you only have so much beer, you're going to just kind of split it up in the same way that you would be splitting up the beer if you had enough beer, in the same proportions, but of course in lesser quantities. What I like to build into a distribution agreement is where that's at your discretion. So if you are low on supply and you have distributors begging for it, you can make the call on where your product goes. A lot of distributors will agree to that. It makes sense, I think, because you know your supply and demand, and you can gauge where it's best going to be served. And a lot of times it's going to be your home turf. Maybe you don't have enough product to satisfy somebody 8 states away, but you want to have enough beer to protect your home turf and make sure you have all the tap handles maintained and the shelf space maintained and so forth. More distribution. I told you I love this topic. Love it. So some specific requirements you can negotiate into your agreements are frequency of meetings. So a lot of times they'll say we're going to meet annually, but you can say I want to meet quarterly. You can negotiate inventory minimums where you say you're going to keep this much of my product on hand, and we're going to meet annually or quarterly or whatever to determine what that minimum is. Shelf life we already talked about. Storage criteria we talked about. Handling of your cooperage can be a massive issue because breweries lose a ton of money in losing kegs. Make sure you have an agreement in place that says the distributor is going to handle your kegs appropriately. You know what the deposit's going to be, and try to get as many of those kegs back as you possibly can. Sales requirements, what I mean by that is minimums. You can establish sales thresholds for your distributor, saying if you don't hit this particular threshold in this amount of time, you're technically in breach of the agreement. A lot of them aren't going to agree to that because it boxes them in too much. But you can at least set up where they have to make commercially reasonable efforts to achieve those requirements. That can at least keep them on their toes. And reporting, just make sure you're getting all your depletion reports and all your lists of accounts and so forth to make sure you're well informed. And a lot of the point of all these specific requirements is if they're not doing their job, you need to be able to point to these and say, you're in breach of this agreement and you need to either fix this breach or I'm going to terminate this agreement for cause. Sometimes that's going to be your only way out of the agreement without paying for it. And in some states, it's going to be your only way out of the agreement because you can't pay to get out of it. So the more specific requirements you have built into the agreement, the more opportunity there is for them to breach that agreement. Other protections you can do, start with a small territory and limited brands, build your way up once you've established that you're happy with your distributor. Negotiate the brand buyout in advance. Say what that fair market value buyout amount is going to be in advance. A lot of times we'll establish that at like a 3 times or 4 times net revenue for the distributor over the past year. So you've defined what fair market value is, and you know what it's going to cost you to get out of that agreement. Negotiate what happens if the distributor is sold. We had that come up very recently in Portland where Anheuser-Busch came in, bought out one of the distributors, and left a lot of breweries wondering what's going to happen. My clients knew exactly what was going to happen because they knew what their options were because it was built into the agreement. Make sure you know what happens when your distributor decides to sell their business. A lot of that's going to be governed by state law as well, so you have to work within that framework. But there are ways to work within it. And again, have a lawyer review it. These are legal documents, and they're extensive legal documents. And there are a lot of laws surrounding these documents, so a lawyer can help you with that.
There's a couple of questions.
Yeah.
If your distributor is losing your kegs, can't you make them pay for them? Question.
It is a good question. I don't know that you'll ever find a distributor who says, I'm going to pay you the full value of that keg if we lose it.
Well, they won't admit to losing it.
Exactly. Exactly.
That's the problem is like, how do you actually prove where it got lost?
And they're going to give you a deposit on that keg in most cases. And if they lose the keg, you get to keep the deposit. So congratulations, you paid $120 for a keg and you're going to get to keep 30 of it. Unfortunately, that is the status of the industry right now, and I'd love to see some change there, but I don't see it happening anytime soon.
We have existing retail accounts for other products, for example. Will they tell us so we can call on that account to get them to sell that product? They have other retail accounts for other products, and you want to have that as a channel potentially.
Let's see, so if they have other retail accounts. Oh, I see. Okay, yeah. Yeah, you can get a list of what all their accounts are, what all their established accounts are. And then you can send your sales force out there, and your sales force may be you in the beginning, and you alone, but you can go to that account and try to sell some shelf space to, or get your beer on their shelf, absolutely, or get a tap handle.
Were there examples of agreements, contracts available for?
You know, I don't know that I probably can't share any contracts that a distributor has given me. I'll talk to Melly about that and see if we can get you an example.
We could probably talk to Aaron, a distributor that we've used in the movie that you guys saw. He might give us something.
That'd be great. And I have an agreement that I use for distributors. Most distributors have their template agreements. I've been more and more trying to press to use my own agreement simply because it's more supplier friendly. So that might be something I can provide. GPS tracker.
We'll go over 7 o'clock a little bit. Do you have time to go for a few more minutes?
I do, yeah,
okay.
Sure.
Just because we got to have that glitch at the beginning, we'll try and, for those of you who have to leave at 7, but we'll go like 10 minutes over to try and get through our content.
And just to get through the rest of the questions here, too many kegs lost because for termination of the agreement. Possibly, if you've built that into your agreement, actually, I might use that. Thank you. If you've built into your agreement that you can only suffer so much of a percentage of keg loss, and it would be a breach, that's a possibility. I can't really see a distributor agreeing to that, but it's a factor. It's one of those factors that if you needed to get out of your agreement, you can certainly mention that we have this in here that they're going to protect my keg supply and get them back to me, and they weren't doing that. So that's certainly a factor you would list. GPS trackers for kegs, I think they're out there. They're very expensive and not being used a ton yet, but the services are out there, as are keg leasing services, which a lot of people are starting to use. That way you don't have to worry about it. They have to worry about it. When you donate products such as bottles or kegs directly to retail locations for purposes of tap takeover, that's, what's that?
I thought some states don't allow you to do that.
I think most states aren't going to allow you to do that. That's one of those three-tier system limitations where you can't really, it's considered like providing,
corruption, bribery.
yeah, providing financial assistance to a retailer. But check with your state. It may be allowed in some cases, and there may be, in some cases, it may just be a monetary limit. I know in Oregon, distributors can give a certain amount of like display cases and things like that of a certain value. There's a limit to that. I think it's like $250 or something like that. So there may be an exception there. You mentioned having to declare all new equipment for TTB.
I don't think the press, if you get a new press, you have to.
I don't think so. Yeah, I don't
I
think
think it's like if it's a still, if it's a, something that looks like it's more directly connected to alcohol.
Yeah, I mean, if you buy a new computer for your brewery, you don't have to tell the TCB about it, as far as I know. The safest way to do it is if you get a new piece of manufacturing equipment, call the TTB and ask them if you need to report it, or just report it. It's not going to do you any harm to send in the paperwork. Okay, so I'll try to move through the insurance part really quickly. These are the various types of insurance you can get: commercial general liability, liquor liability, employer practices liability, workers' comp, auto, personal property, earthquake, and flood, which are more specialty insurances. And then there are the specialty insurance coverages for the brewing, cidery, and distilling industry, which are things like equipment breakdown insurance and tank leakage insurance, which are basically attached as a rider to your general liability policy. And I didn't know that until today. I have to thank my friend Jason Jordan of Ross & Associates Insurance for giving me the lowdown on these things. He also pointed out that more and more the insurers are looking very closely at your business before giving you coverage. So they're going to look at your business plan, kind of like a bank will, and they're going to look at your pro forma financials, and they're going to make sure that you are a secure new company before they insure you, because they're making sure their risk is minimized. Another thing the insurer will do is send out a risk advisor to your brewery if you request it, and they'll walk around with you and say, you should change this, you should change this, and improve your workplace safety, basically, to make sure you're not subject to claims. They'll tell you things like you should keep your grain mill in an enclosed space. They'll talk to you about ventilation and the use of plastic kegs versus aluminum kegs, things like that. That can be a big deal to them because people get injured and they lose money off of that. Liquor liability, look at your state law for minimum requirements for your liquor liability. Liquor liability is the dram shop liability, where if somebody is overserved at your facility, goes out and gets in a car wreck, you can get sued for it. So look into minimums on that. It's $300,000 in Oregon, but you should have at least $1 million in most cases, because those are pretty hefty lawsuits when they happen. Employer liability is an optional coverage, but it can be extremely important, especially if you have about 15 or more employees. That's going to cover things like discrimination claims and any claims by employees against the employer. Bonds, just real quick, these bonds, you're going to be required to get a bond for the TTB in some states. It's going to cover your tax liability for the beer that you're storing. Just take a look at the TTB requirements for the bond. A lot of times an insurance agent can hook you up with a bond, or the TTB, I'm sure, can give you direction on where you can get a TTB bond. The TTB brewer's bond is valid for 4 years. I believe the distiller's bond is perpetual. I don't think you have to renew the distiller's bond. And in states, it's usually a 1-year renewal term. And liability protection, we talked about this a bit in the last section, in the last class. Just make sure you're covering all your corporate formalities, acting like a corporation, having your separate bank account, keeping all your finances separate, keeping adequately capitalized, and all those things to make sure that you can't be attacked by creditors. Financing, and this one, again, we can run through very quickly. The sources of financing, and I had some help from my friend Patrick at Bank of the Cascades on this one. Institutional financing, private equity, private loans, municipal public development organizations, crowdfunding, landlord-tenant improvements. Institutional financing is your bank loans. Banks are becoming more and more friendly to breweries after the economic collapse. They're finally getting back on board with these companies and starting to not treat them like restaurants, which is nice. Private equity can be great if you have people who want to invest in your brewery. Just make sure you follow all those securities regulations that we talked about in the last class, and make sure you're not giving up too much of your company. Private loans, fantastic. If you have a rich uncle who wants to loan you a bunch of money on favorable terms, it can be a great source of capital. Municipal public development organizations are, a lot of cities, most cities I would say, have these. It's where they basically have these funds in place for neighborhoods that they want to improve. So you might be pulling into a neighborhood that has a lot of financing options available through these organizations. You might not be able to get it elsewhere. Crowdfunding, things like Kickstarter and Indiegogo. There are even a couple of sites popping up specific to the craft brew industry, such as Craft Fund. I think they're still doing it.
They're probably going to do a live session too.
Oh, good. And landlord-tenant improvements, which we already talked about. We already talked about sale of brand rights as well as a kind of an upfront income source. Contract brewing can be a great income source to get some capital in before you're in full production and selling your own brand. And beer clubs, I think you've all probably heard of these, where your patrons pay $100 and they get a mug and they get a discount on their beer. Be creative, but make sure that whatever funding sources you're getting are done in a legal way.
Also, for those of you who've already looked at the Ale Apothecary video, you can see that's a source of getting your money before the beer is actually delivered to the customer. Subscription club.
Oh, very nice. Very nice. It's safer to form two companies, the brewery and a separate equipment leasing company, or the brewery leases equipment from. That way there's a liability issue and the brewery is sued. Brewery can fold. Okay.
Geez, sounds like a lawyer.
That's a good question, and I'm going to say it depends. I think it can be a very good arrangement, especially if you have investors who maybe don't want to invest in the operational side of the brewery because they see too much risk in it, but they're willing to invest in the equipment side of the brewery because they're secured by the value of that equipment. That happens a lot, and that can be a good setup. I've seen this situation backfire, and that can happen because you have two different companies. You have varying interests going on in those companies, and if the powers that be within those companies, there's variation in the ownership of those companies, and they want to go different directions. Of course, that can cause a lot of problems. You suddenly have a brewery that may not have any equipment in place because the equipment company wants to pull out. Now, if you want to just have ownership in common, management in common, set them up as two separate entities, that can be a pretty good arrangement. Just make sure it's all documented. The brewery should probably be paying a lease amount for the brewery, for the equipment. Make sure it's all done above board. Employment, just be careful with state and federal laws. The more employees you have, the more you're going to be subject to. So Family Medical Leave Act laws can kick in after, I think it's 50 employees at the federal level, but at the state level it can be a much lesser number of people. ADA kicks in at a smaller number. I can't tell you off the top of my head what that number is. And be careful with wage laws. They're state by state, and there are a lot of penalties and attorney fees involved in those.
Things like overtime.
Yep, minimum wage, overtime, payment of last paycheck when somebody terminates their employment, payment of commissions, things like that. And especially when you're talking about a commission employee, make sure that commission arrangement's in writing. And that leads to employment agreements where not only are employment agreements good for things like commissions and payment structures, benefits, and so forth, but it can be great for the brewery to establish the confidentiality of their information, protect their intellectual property, and make sure the trade secrets are protected. Your recipes for your brewery are not copyrightable, but they are trade secrets. So if you want to, we talked about this a bit last time, if you want to protect your recipes, protect them as trade secrets from your brewers. Make sure in most cases that your employees are going to be at will. That way you're not tied into a employment for a term and you can terminate your employees whenever you need to. Employment's it's a huge area of law. I'm just barely touching the surface here, so that's
minimum number of employees where they have to offer medical insurance.
Under federal law, you're of course under Obamacare, like you point out, and that's going to be 50 employees, but it's not kicking in until 2015. It's an incredibly complicated law at this point with very few guidelines, but they're working on that. I've done a ton of research on it, and I still am utterly confused about some aspects of it. But what I do know is that in 2015, if you have 50 or more employees, you're going to have to either provide medical insurance at a certain level or pay the penalty for them. And sometimes the penalty is going to be cheaper than the insurance. That is the last slide. I apologize for going over there. But there's my email address again if you want to ask any direct questions. And I also listed the web address for the Beverage Industry Networking Group, which Melly mentioned last time is a network of service providers to the brewing industry. Our website is absolutely horrible, so I don't advise getting on it right away, but we're working on it. Hopefully we'll have some better information up there soon.
Yes, slides will be posted, and let me put in a plug for the Brewery Industry Networking Group. They have really fun events. Often I have to teach the nights they are having events.
Unfortunately.
But they had a big party at at Crosby.
Yeah, we have an annual party at the Crosby Hop Farm. I think about 100 people showed up last summer, and it was an absolute blast. So we're going to be doing that every year.
Post says cheers.
And if any of you brewers from out of state ever want to come out to the annual Crosby, the Bing Crosby Hop Festival, as we call it, you're welcome to join us out there. So just let me know if you want to jump in.
Any other last-minute questions? You guys ready to go off and have beers? Okay, great. All right, we'll see you in a couple more weeks. We're doing this every other week, so be prepared with your questions if you have any.
Thanks all.
Good night,
Cheers.
all. Cheers.